do want to cover is just simply, let's recap slightly from yesterday. It's all about contracts. It's all about agreements. Almost the whole procedure of human life implies, or rather is, the continual fulfillment of contracts. So we can simply say continual fulfillment of contracts is the essence of the whole game.
Could you say again where you read that from? Was 1906?
I read that from a set of 1906 law books that were brought into prison by a buddy of mine. A hardback set that was from some law school or course back in 1906. And in one of the books on contracts, that little comment was, almost the whole procedure of human life implies, comma, or, comma, rather, comma, is the continual fulfillment of contracts. And that stuck with me. And we have some interesting, and we have, as I told you, the whole game is offer and acceptance, right? Which forms our contracts. You know, we have a lot of people talk about, well, a contract is a meeting of the minds and consideration given and all of that kind of thing. You've heard some of that. So I don't have a contract with him. I didn't consent, or I do not consent to this. We go back to a simple statement. Contracts are either express or implied. Contracts are express, it's not either, express or implied. The express are manifest. Viva voce, or by writing. The implied are shown by silence, by acts, or by signs. Contracts are express or implied. The express are manifest viva voce, or by writing. The implied are shown by silence, by acts, or by signs. That's really important for you to understand, because this is going to go. I have some questions here handed up, and I think they're very good. Number one, all contracts start verbally. Is this true? Well, let us refer to a major principle and rule of contracts. So they don't start verbally. Let's say I'm a police officer and I stand in the room, I'm doing this, some guys are watching, and the officer goes, and you go do it. Is that an offer? You accepted it? Is that a contract? Or if he goes, I told you about my friend that was at a drug halfway house building, or I may not have, in Orange County. He's outside with about 30 other guys on a break when a police car pulls up with 2 officers in it. The officer says, and this is a paraphrase of the overall deal, says, "You, come here," to my friend. My buddy says, "Why are you accosting me?" Accost means to approach and speak to first or greet without being greeted. It's just a question. Why are you accosting me? The officer repeats, "I told you to get over here." My friend responds, "May I see some identification?" The police officer responds, "This car and this uniform's identification enough. Offer acceptance, offer acceptance, offer acceptance." Or conditional acceptance, whichever you want to call it. The officer proffered, "This car and this uniform." That's his offer. My buddy says, "Are you refusing to identify yourself?" The officer turned and went to someone else. There's more to the story, but sufficiently. So are contracts verbal? Do they commence verbally? No.
Now, how come in that
They can.
interaction, the police officer is always giving an order, and your buddy's always asking a question?
Why do you asking? Why are you asking? As king. My buddy's asking so he does not grant jurisdiction.
But what about this?
But if the police officer makes his demands, is he not refusing you?
Excuse me?
He's not asking a question. He's not trying to.
The police officer?
Yeah.
He's giving a command, isn't he?
Trying to get jurisdiction.
He's giving an order,
Yes.
hoping you'll fulfill the order.
Right. If you fulfill an order, if you give him an order back.
And what did he do? That's right.
Arguing.
Yeah, but okay. But how come I'm arguing, but he isn't?
Under the law of presumption, under presumption and assumption, he can assume you're one of the cattle.
Yeah,
He's just doing his job.
that's
Yeah,
nature.
okay, I understand that, but why do we have to live under presumption? We're trying to live outside of that, right? We're trying to learn to live as sovereigns.
That's over thousands of years. But with the you who were here, like, how can I gently say, like, no?
You can't gently say no. That's pretty ungentle.
So yeah, so
How?
with this action,
Why are you accosting me?
do I have to verbally say it, or can I just go fine?
Why not? He goes,
Fine. Yeah.
why not?
Yeah, no, that's my option.
You could.
Why?
Okay.
Because I've done that in police. Like, I'm just driving along, and the guy goes, "Pull over," and I go, "What? Why?" And he goes, "No, go ahead." He's looking to see if I have a seatbelt. Yes, and he sees it. Oh, okay, no. Yes, why?
You know,
Okay, yeah.
some guy's going like this. You know, I don't even see him.
Yeah. That's
I don't see anything in the law said a guy going like this you got to do. What law says I got to take his order?
Yeah.
There's a long way. It's all offer and acceptance. How are you going to offer and accept? But you know,
Yeah.
this isn't how police officers pull people over.
Yeah.
On the freeway, they do.
Well, they can, but you know, you can do that all you want.
Yeah. That even if he pulls you over, it's like, who are you? Yeah. Okay.
It's granting jurisdiction. Stop and try and think, why does anybody have jurisdiction over anybody?
Because you allow it.
Has to be consent.
Yeah.
Remember, governments are instituted by the consent of the governed. Are you going to consent to be governed? Well, I don't know. Do you need pulled over? Are you driving a state car? You got a private plate on your car. That's where it gets a little more tricky. But nonetheless. So, all contracts start verbally. Is this true? No, they can start by signs. They can start by just whatever. Because contracts are shown also by silence, by acts, or by signs. Yo.
That was an offer. I just raised my hand.
Yes. And I accept. What's your question?
That was it.
The written contract is the verification of our verbal contract. In the documents that I have on the Brian Blum stuff that some of you have gotten, page 50 at the bottom, the footnote, page 50. Turn to that if you wish. There you go. The offer, the objective test of contracts off Brian Blum stuff. The bottom of page 50, the footnote. It says thus. I really like this statement. In colloquial speech, people often talk of signing a contract. And the quotation, signing a contract. Strictly speaking, this is inaccurate terminology. The contract is the legal relationship between the parties, and the document that is signed is actually the record or memorial of that contract. And that's really, I love that statement. And I've internalized that statement because I use it. I had that divorce case up in San Francisco. The gal had been legally married 3.5 years before. In other words, formalized it with a license and a ceremony and all that. But yet she had moved in with this gentleman 11 years previously. So my position was, when the other attorney said, well, California law says this, I said, agree, California law says that. However, and then I quoted that statement, in colloquial speech, blah, 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 blah. I said, my client got married 11 years ago. And I'm going to take half your client's home, and I'm going to shove these bills down his throat. I said, I didn't want to be mean about it, but I can see that we're dealing with a very mean-spirited guy. She's walking out with nothing after 11 years. And he's got a home with that, and that isn't what their understanding was. Therefore, she says, let me get back with you. 3 hours later, we had a deal on terms acceptable to my client. Quickly thereafter, the paperwork was signed and done. Like 2 days. Over the weekend, actually. So, it's important to understand what does constitute a contract. If you read Brian Blum's book, you read Williston on contracts, Restatement, Second. There's all sorts of contract books. Get one that has explanations and examples, such as Brian Blum's. And it's only when you see all these explanations and examples that you realize how intricate a contract is. Because they use Blackacre Farm and somebody offers to sell it or whatever, and what constitutes an offer and how the verbiage, and they give you sample little notes and napkin notes and things, and you go, whoa, I see how what constitutes an actual offer under the law, etc. I was dealing with I'm dealing with a couple of people that have been terminated from their jobs. One was a Hewlett-Packard person after 29 years, and another one is a gal with Siemens Company back east after 24 years. They just up and terminated her. Well, she took their offer, and we've countered that. We conditionally accepted. She's an at-will employee, means they can just terminate at will upon proof of claim. That, over the last 200 and some odd months, did not constitute her understanding of an agreement to be there for till she retired. So we're back and forth with Siemens right now, because she has a contract till she retires in her mind. And do you have that stuff on?
Which one?
There's a little bit on at-will employees, something, just 1 or 2 pages.
I didn't get that.
It's really an interesting comment that some courts have held, that you're no longer an at-will employee if you have
Right.
if you have relied on, they call it, job security. Well, what's job security? After a year or 2 years, you're deemed to think that you're giving your loyalty. And there's a real nice way to do it. I can get you some of that if you want it. But to be terminated from a job at will is not going to be. Didn't you have an understanding you're going to be there till you retired? The Hewlett-Packard gentleman, he says, I was first there when Hewlett-Packard got started. We used to have the rah meetings. We were all going to be here to the end and this and that. He said, this isn't right. I said, well, there's your contract. He understood that he had a contract for life. So he conditionally accepted their offer to be terminated 9 years early upon payment of, one, a lump sum of the 9 years remaining on the contract as he understood it, or the continuation of it, blah, 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 blah. So we were doing back and forth with conditional acceptance, offer and acceptance, back and forth with the company, including but not limited to several of its officers personally. So it gets kind of exciting.
How did it go?
He was doing pretty good. Unfortunately, he had a heart attack recently and died, right in the middle of it. So we're in the middle of the Siemens one right now.
So that terminated that contract with everything.
Yeah, so,
Because I was reading about that, death.
Well, he's history. He doesn't exist anymore. He's not there to discuss it.
Yep.
So
What about the woman?
the woman, we're right in the middle. We just started. You just started recently. We made our offer. They've countered one now, and we recountered back to that the other day. It'll go on for a few more, and we'll see what's going to be. Otherwise, we've got numerous officers that are going to, in our opinion, are going to have liens against them, much like the warden. Are you sure you want to terminate her?
Can you just speak to the time frames in terms of reasonable time periods for which the other party has to respond? And,
We gave under law, we give them 10 days to respond. 3 days for mailing there, 3 days for an agreement, contract law, and 3 days for mailing back on a Sunday. So
What about when we receive an offer, like I'm going to be terminated from my job and I don't talk to you for a few weeks or something, or...
well, you were given an offer.
No, I'm just saying, hypothetically, when we receive an offer, is there a time? I mean, obviously, the faster
Is there a
the better
time for you to respond?
in terms of conditional acceptance.
Well,
I get
technically,
it.
after 72 hours, you have a contract, don't you?
Okay. Yeah.
However, let's use, for example, the gentleman, the John Stewart, that was accused of second-degree murder. I enter the case over a year later, so we go back and grab a 1-year-old indictment, and we do our conditional acceptance on it and backdate it.
Backdated.
No, pro-tunk.
Yeah, nunc pro tonque.
Yeah.
That's an offer, right? So on the acceptance, I date it back in some month in 2008, and in next to the date I put in parentheses nunc pro tonque. Now for then. So I just said, hey, I'm submitting this back for way back when. They got a right to accept it or not, don't they? What do? They agree. Okay, we'll accept it now for them. Or they could have said something. I've had some judges do it too on some of their documents. That's where I picked it up from.
That's right.
It's really good stuff. It's really, I'm trying to get you to understand. You got a lot of power, and if we can get you to understand, it's simple offer and acceptance. You got 4 doors to go through. You need to be timely in your responses. But even if you miss something, it's okay. But now when you get into a public arena, like we've got 2 doctors in Cincinnati that are dealing with federal indictments. They were in a hearing recently where they messed up some stuff. They said, now what do we do? Just the judge issued a couple orders based on what happened in that hearing. We pulled those off the docket sheet, certified copies of them, and we conditionally accepted them and put them back in honor. And one of the things he had done was a modification of their their release during the trial with probation department. And he said, because they executed in open court that they were going to put the trial off till January instead of being in September, so they kind of got excited about that and agreed to it and signed on it. Well, they set the thing off. Why are you agreeing to have a trial if you see they messed up? They got lax and it's okay. You get a chance to fix things. But because of that mess up, the judge then went on further into the matter and did a modification and this and that and said, you're going to report to the probation department and turn in passports and 5 other things. You got to report any contact with the police, if you're taking any prescription drugs, etc., etc. So they were going to, now we got a problem because they put everything in and we had them go ahead and show up to turn in the passports. But when they did, they came into and it was like they were stressing out about the meeting and messing up because they're pretty conscientious guys, and when your life's on the line, you're stressing all the time on it because this is one of them's facing like 75 years and the other's 83 years on this stuff. So that's that's very effective, That'll have you having your sphincter in a serious contractual mode there, So the long and short of it is they went into the supervised things and introduced themselves. I'm here today as Bruce Marusik or Brad Brennecke, intervener for the purpose of helping the parties settle all claims or charges. Would it be all right if we turned in the defendant's passport? And they said, sure. I said, okay, great. Much like when I was in court and the judge gave an order at the end of the first hearing, he says, I'm giving you an order to be here next week on da-da-da-da. And I said, would it be all right if I came next week at the day? And he says, I have another matter to hear now. It's not so much anything other than who's asking the questions and controlling the situation. Judge says, sit down over there. Judge, would it be all right if I sat down over here to help settle and close the matter here today? What's he going to say?
See, conventionally it sounds like you're still asking an authority figure for permission to sit down or something.
Yes, in that sense you're correct. But when in that world you're trying to find that happy medium, so you'll get to it. We could not go to the probation. The guys in Cincinnati could not go to and just. We put in a conditional acceptance to the judge's order, but we've got to show up. Let me give you a thought. When I first commenced supervised release when I got out of prison, I was going and seeing the psychologist because they wanted me to go once a week to see the psychologist. And it was very strange because I would sit there with the paper and the pen and take notes while he yacked for an hour. Jack and I just were just I said, Jack, you got to be there. This is too much. I'm the doc and he's the patient. He would once in a while ask a question. I'd probe with another question. He'd run off and start talking. I'd just be taking all these notes. I got all these notes I took. But see, that isn't what the issue was. What was I there for? I was there for simply to take a benefit. It had nothing to do whether you're seeing Martians and this and that and the other thing, or you're wacky. It's got nothing to do with that. It has all to do with getting you to take a benefit. And I was taking a benefit. So once I'd completed all of my paperwork to set off, settle, and close the probation and the case and all the stuff as I saw it, I had given... Who has the 11 pages with him?
It's right here.
Hold on. I had given a copy to the... I had given a copy to... Is this the 5 questions? Where are they at? You can grab them from... I had given the psychologist all this paperwork too. And he always set a new appointment. So at the last hearing when I'm ready to break away. I've settled the case. I've given everybody notice. I'm not going to be doing any more supervised release or anything else. There was a series of questions that are in here under J&J. It's toward the end. It's like page 9. And it commences at the top. Is it not true there's both a public and a private trust that run parallel in today's society? Are you aware of what I'm talking about in this 11 pages? The 11 pages of Q&A, for your information, were put together by Jack and myself to respond to everything I was doing on a revocation hearing for supervised release for myself. So these were questions and answers, or just answers to things I think he might ask. So that's your backdrop for understanding all these questions and answers.
And what does the J and J, and then down below just a bunch of J's, what does that refer to?
Well, one of them, I think, was this one up here was Jason over at the psychologist thing, and all these J's down here was for the judge. So that top question, so I commenced with that psychologist. He said, well, we need to schedule an appointment. I said, can I ask you some questions, Jason? He said, sure. I said, is it not true there's both a public and a private trust that run parallel in today's society? He goes, yeah, we talked about this yesterday, remember?
Psychologist said yeah.
He said, yes. I said, is it not true that the public has not the resources to resolve all problems in private? He goes, true. I says, is it not true the only reason that public trustees are involved in any problem is because the private parties have failed to resolve it? He goes, true. And then what's the fourth one here? Is it not true that most problems the public has as a result of the private parties failing to resolve the problem, blah, blah, blah? And he goes, true. And then I said, are you suggesting that the record I provided to you, which has resolved the matter in private, still grants jurisdiction in the public to continue a matter already settled and closed? He goes, I see your point. I said, have a nice day. Didn't make another appointment. Now, what was his job? He called the probation department, the gal there, named Janet Berglund, really a sharp gal. She calls me up and says, you call him and you make another appointment now. I said, sure. So I call him up, make an appointment for the following week, and I go in. And he says, well, come on in. And we go into the office. And he said, I said, excuse me, before we get started, Jason, do you recall that set of questions we discussed last week? He goes, yes. I said, are you suggesting that the record I provided you, blah, blah, blah? And so he tries to get me in there, and we're talking for 15 minutes. I keep coming back to this. It's all I want to discuss. I don't want him to let him put, well, just come on in, let's talk about a few things anyway and clarify. I said, what is there to talk about? Are you suggesting? And I just kept coming back to it, and I left. We're not resolved, not making another appointment. Janet again calls me up after hearing from him. Call him up again and make another appointment. I call him up. Jason Gordon. He says, hi, how you doing? I said, great. Something along this line. And I says, Janet requested I make an appointment with you. He says, is it just going to be the same thing as before? I said, why would it be any different? He says, there's no point in having an appointment then. Thank you, goodbye. He's the Data Integrity Hearing Board officer. He's going to report back to the judge what? The guy's crazy? Or the guy is not going to let me give him a benefit and burden the public? And he's acting like one of them damn sovereigns. And that's the way Jack and I saw it. And man, let me tell you, for the next week, I was like, am I going to be arrested at any moment, Have I made a mess? Because I wouldn't call in for urine testing. I stopped everything. I'd gone and given each of them the record, this and that, and boom. And a very interesting thing happened. Remember, I told you that the goal is for them to get you to argue or any other thing, kind of like the Walmart attorney and the other things. They need an argument. I get called into the probation department gal's office, and that weekend there was somebody did a pipe bomb over at the courthouse across the street in front of the courthouse doors. Some fool, some idiot. So when I walked in, apparently there were some new news crews over the weekend there, obviously, and might have been on Monday there. So I walk in, I'm up on the floor, I don't know, 9th floor with her or something, and she goes, "Did you see the news crews? This is how the meeting starts." I says, "No." "What's it about?" She goes, "Somebody had did a pipe bomb over the weekend." I said, "Whoa. Any damage or everybody hurt?" "No, just some window blown out on the 8th floor on a building across the way, and basically nothing. But very dangerous nonetheless." She goes, "And I was worried it was you." What are you going to say? That's a kind of interesting comment. I says, "Why would I do such an egregious act to a government I love?" And for the next 35, 40 minutes, she attempted to provoke an argument. "You know, when you first started, you were doing great. I thought you were going to be fine, and now you won't do anything, and then, and that, and that, and that." I just looked at her. It's all true. And you're out doing contracts you're not allowed to, and you're traveling out of the district, and it ends very interesting. She goes at the end of like about 35 or 40 minutes, I know she goes, I don't know you. I don't recognize you. And I said, does this conclude our business? And left. And I had this real strange feeling there was a couple marshals in the office next door or something. But I continued to maintain my status as I understood it by asking questions and being very humble and gentle. And normally where she always walked me out through this labyrinth of hallways, she opens her door and says, go. And when you look up recognize or know, she recognize is to treat. She didn't recognize me more. I'm private, not public. She doesn't know me anymore. Very interesting. And over the next bunch of months, more and more paperwork back and forth, till she called and invited me down to pick up a citation, which was nothing more than a summons to come to court to have a revocation of probation and be thrown in jail. And that's when the first hearing was. And I sat in the back, and the judge just calls out, "It's Gordon Hall in the courtroom." And I stand up and say, "I'm here today as Gordon Hall, secured party creditor, private trustee for the blah, 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 blah." And negotiation was on, and all sorts of interesting things happened. It was the fifth hearing before I screwed up, which was like a month or two later, because we had these hearings being set. And I couldn't see the forest through the trees at that time to understand how to close the deal. I do clearly now. It's kind of easy. But then it was like, couldn't get there. So, the written contract is the verification of our verbal contract. You could say it's a verification. It's a record or memorial. A reminder is what a memorial is. It's kind of interesting because some courts, when you go and you get like insurance contracts or these mortgage documents, you just sign stuff because you're not going to be reading all this crazy stuff. We've gotten used to not reading what we sign. Those are called adhesion contracts, take it or leave it contracts. You're required, there's got to be insurance and this and that. So when you end up signing some of these adhesion contracts, much like with Western Union, the people that sent me money signed paperwork to have the money wired, and in fine print it says it can take up to 5 days for the money to get there, going through correspondent banks and blah, 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 blah. Your correspondent banks, etc. Not yours, it's theirs, why they float the money. And those are adhesion contracts, and they've been set aside many times because of that. Because lay people, because that's not the contract, is it? Just like the farmer's insurance deal I'm doing down here in San Diego on the claim with one of the guys. When he gave the agent the fees to cover all of his stuff and it got missing or stolen or whatever happened to it, $8,000 in damage, he put in a claim it was denied because it wasn't covered. Well, the agent made a mistake and said it was covered. I said, "Will the agent give you an affidavit in that?" He goes, "Yeah." I said, "This is a done deal. We can get it done anyway, but with that, it's a laydown." We put in our claim. They said, "We don't have anything that shows that lead us to believe that." We submitted the affidavit in support, and it's an interesting one. They'll end up having to pay it. But that doesn't mean they won't go through a few machinations first. So it gets kind of exciting because the bottom line is the contract is not the written thing, technically. You made the agreement before ever you signed that. You know what I mean? Guy says, "Okay, let's do this, this, and this," and then they say, "Okay, here, sign it." Well, this is just a record, a memorial of your contract. So if you can get that through your mind. So does the verbal contract precede the written in authority? Well, again, depends on the situation. Let's say that I sell you a car, and I give you a bill of sale, and it's for $1,000, or any other kind of contract. Does the verbal always override? I think that's what you're at. Is the verbal more? Well, think about the San Francisco one. Here we have a written one, California law and all that, but I say the contract, which is the verbal one, if you want to use it that way, got a written one and a verbal one if you want to use a layman understanding of it. The verbal one in that case will always supersede, because how do we know? Because the actions speak louder than the words, and she knows how to make the claim. How she know how to make the claim? Because she knew how to have me do it. That's how. So, and well, can I? Where's the paperwork said to what she did? By putting in a statement of facts supported by an affidavit or in a negative averment form, unless you know how to respond to one of those, not going to happen. You're going to lose the case. So this is where it's important the truth be on your side. She could say, I moved in 11 years ago. And when I moved in, I brought my furniture and yours was thrown out. And I've made more money than you have over the years. And we used my money for expenses and different things. And yours was used for the house payment. But those are all facts that a guy cannot testify are false, can he? He's going to admit she moved in 11 years ago. That's not any misunderstanding. He's not going to deny that she gets paid more. That's why he's under California law. He's getting spousal maintenance and money and having her pay the bills. But that's California law. And we're not talking California law here. We were talking contract law, which supersedes California law. California law is another form of contract law. Sears has contract law, and McDonald's has contract law. If you're a McDonald's employee, you're going to cut your hair, you're going to wear this uniform, you're going to show up on time. That's the law. Or what's going to be the penalty for not doing it? You'll be terminated, or fired, actually, as opposed to termination, because you have broke the contract. Termination is a breaking of the ending of a contract without it being broken by either side. You don't become your brother's accuser. That's why this gal in Siemens, they're wanting to terminate her. They're not firing her. They're not laying her off. They're terminating her. Ending the contract without it being broken by either side.
Then they're assuming there is a contract.
Very good. But they're saying it's based on a contract that was actually memorialized via an at-will agreement based on the company she originally started for. Siemens bought them out. So they're saying you signed as an at-will employee. Yeah, with that company, not Siemens. Siemens bought that company out. So we conditionally accept that I'm an at-will employee under that memorial upon proof of claim that when Siemens bought that company out, they gave within 30 days, they gave notice, a written notice, that she was still an at-will employee for Siemens. Can they do that? They don't got one of those. So, hey, we agree, just where's the written agreement you notify us within 30 days, blah, 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 blah. So ours will stand against it. They'll have to come back with something. So game on. Tink, 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 back and forth. Bottom line is, did she put in 258 months? Did her actions not indicate her loyalty and her understanding of a long-term agreement? Can't say no to that. 6 months or 12 months maybe, but not 24 years, not 5 years, not 3 years. Probably hang under 3 years, kind of like the sort of rule that you're sort of like an at-will employee still. You don't have a detrimental reliance that you were hired for long-term. I contend differently. After 2 months or a month, I'm long-term. But hey, do you know how to make a contract and enforce it? Let's give some others. Yes.
Would you say that there's different levels on which this game can be played? You just said a minute ago, here's what happened to this woman or this person, and they can't argue with that because that's what really happened. But yesterday you said, well, you can't prove anything.
No, you can't.
But you can, if you know how, you can disprove anything.
Well,
so
remember, how is something proved? Something is proved by the other side agreeing with it, right?
Right.
So when I sent in the initial response to Siemens or Notice Private International, our constructive notice of conditional acceptance to their offer to terminate, it was upon these state of facts, and then we put a vermin or an affidavit in support of that. We've seen no evidence, blah blah blah, believe none exists, blah blah. So we just made some statements. And in commerce, understanding the rules, in commerce, truth is sovereign.
Yeah.
Truth is expressed in the form of an affidavit. An unrebutted affidavit stands as truth in commerce, and an unrebutted affidavit becomes the judgment in commerce. So that's the rules. There had to be some rules set up for all of us to interact in commerce. And those are some of 4 of the 10 rules of commerce. There's 4 basic 10 rules you can get at it a whole bunch of places, but if you don't have it, I'll get it to Juanita. But it's beautiful stuff.
Because sometimes.
So when I put in a negative averment in support of the statement of facts, if you don't rebut it on your commercial liability under penalty of perjury, then it stands. And I know that, the judge knows that, and if you don't, you're going to find out. So I can't prove it, but you're going to prove it by your answer or non-answer there too. You see? So it's you that'll prove it for me by either arguing or going silent. Because you're not going to conditionally accept. Why conditionally accept upon proof of claim you were actually here for 258 months? Well, let me just give you check stubs. They're not going to do some. They're not going to swear that you weren't there 258 months, right? Under penalty of perjury. Because they're going to jail. We'll refer this for perjury. So all of a sudden, this whole game comes down to you want to go to jail or not. You want to swear? If you want to swear, you may have a problem with if you can't do much and you got a guy that's willing to swear under penalty of perjury, he's likely to potentially get away with it. Two sovereigns, you're not going to get anywhere with them. But like I had a client call this morning. She says, "Do you have Thomas?" Well, she says, "I just got some great news." Her husband was in jail and they had a business, and the employees that were working there, one of the employees let her father come over and take this guy's $3,000-$4,000 Ryder lawnmower like 6 months ago, and he won't return it. She goes, "He won't return it. She stole a bunch of money. What do I do?" The police won't do anything. She reported. They're not doing anything. It's a civil matter, right? I says, "Not a problem. Let's send him a hello, how are you?" So we gave him a notice private international remedy demand. He's a doctor. He got this notice of demand. Your daughter lent you my lawnmower. You took my lawnmower on this day. We made a phone call and requested at this time to return it. You haven't returned it. Therefore, it will be deemed fraud and theft. It's this, and if you don't return, it's $9,000 for that. This morning, there's this racket out there. The guy returned the lawnmower. She goes, "That stuff works, Gordon. It's beautiful. It's working." And we talked to him, and he's going to talk to his daughter about return of money. Because she went into their home and stole some gold coins, like 17 grand worth of gold. I mean, not just a little bit of stuff. This girl did a lot of bad things. And I don't doubt she spent some of the money or a lot of it, but if you can get some of it back, at least it's going to bode well. And the father can see where this is going because the daughter has a child. She said, "Well, what should I do about that?" I says, "Not my problem." I mean, we're going to let her just run around and steal and do from people because she happens to have a child? Well, maybe the father wants to take care of the child because she's going to jail, and maybe he can see that in the writing on the wall. Maybe they all ought to come and work it out. Like, I did wrong. Here's some of the money back, and we're going to start making payments.
One more question. Sometimes Jack Smith and other people say, the facts are on the moon. And
yes.
Sometimes when I hear that, I think, well, it's all just a joke. What the reality doesn't make any difference in terms of some of these things.
In the sense,
but then you also have to merit the remedy.
Well, in the sense that you're dealing with the federal indictment, the facts are on the moon. And in the sense that you're going to argue about facts, they're on the moon. In the reality, that you took my lawnmower is a fact, and that's not on the moon. You took the lawnmower, and you're going to owe some data entry, like $9,000 worth of U.S. currency, which is just data entry. So in a sense, the facts are on the moon, in another sense, they're not. So you got to kind of put it in context. So when we're telling you the facts are on the moon, is don't be arguing the facts. That's not the issue. And certainly when you get a federal indictment or a police officer pulls you over, you're doing 82 miles an hour. 182, 82, that's not the issue. The facts are on the moon. That's irrelevant. The issue is, why are you stopping me? Right. The issue is not the body of the dead peasant girl. The issue is, were your men trespassing or poaching when they found the body of the dead peasant girl? In other words, what are you doing on private property? Just because there's a dead body, there's nothing to do. It's just a errant cattle. Not my problem.
But the issue could be the facts if someone took my lawnmower and I have an issue with that.
Yeah.
Yeah, depends on the context.
Yeah, the context. So in one sense, the facts don't mean anything. When you're being accused of something, the facts are on the moon, okay? I.e. federal indictments. There's a dead body on your private property, so you're going to have to explain it, right? Did you murder the girl? What's she doing there? We're going to charge you as an accessory, whatever. That's all on the moon in the context of dealing with a sovereign or a person in authority, because you don't question the king about a dead body on their property. You don't. If you had property and you had a low-deal title on it as opposed to fee simple, meaning it's private property and posted, and police came and knocked on your door, which may or may not be likely in view of the fact that it's not registered with the county and the fact that it's posted private. But if they knocked on the door, they say, "Excuse me, sir." "Yes." "There's a dead body on your property." "Well, you could maybe handle it the way it is." "So you poaching, or you trespassing when you found this body?" "Because I'm not here to answer questions about the body by anything." "Well, we need to take you in for questioning." "I don't think so." I'm not going to say that, but no, that's not going to happen. Not my problem. It's his problem. So, let's
Gordon,
get...
that exact thing happened to me in April, where I was let go from the company I was with for 4 years.
Well, they just made you an offer. And how you handle it, they made you an offer to terminate you or fire you or lay you off or whatever. And it's just an offer. It's hard to imagine. It was nothing more than an offer. The question would be, if you were my client, I'd say, well, what was your understanding of the relationship? Didn't you anticipate working there right? Did you not commit yourself to that? And then they don't have I should send you, or get through Juanita, get with me, and I'll send you our response to Hewlett Packard and Siemens offers, and you go, oh, I could see what I could do with them on that. Yeah. So as you start getting some of these standardized things, you start realizing you have to come up with all these cute little conditional acceptances yourselves.
It's all starting to...
So, I mean, the fact that it's a few months ago, now that I've got information, I can do something about it.
Yeah.
Well, contracts move because they are dynamic. Is this because we can verbalize them again at any time? Verbalize in writing? Remember, contracts are dynamic. Your agreement's dynamic. I sell you a car, I want $1,000 a month. You call me 3 months later and say, "Gordon, I can't afford this car anymore, brother. I lost my job. I can't afford $1,000 a month. If you'll accept $600 a month, I'll be making the payment." That's an offer. I can say, "Look, you bought the car, brother. If you don't, I'm going to get a judgment against you for the full amount if you don't pay." That's my counteroffer. But if I'm your brother and love you and I listen to what you had to say, I might be kind of a little relaxed about it, right? If you really love your brother. So when you come at it from that, it's kind of like the story in the scriptures. It's all in the Bible. That's what's so good about the beggar that was outside the deal, and the rich guy never did anything for him, and he ends up going there, and he wanted to go back and warn his brothers to be nice to the beggar, this and that. You've been told to love your brother. If they steal your coat, give them your other coat. Does that mean you just write it off? No, not to me it doesn't. Because it also says, spare the rod, spoil the corporation. I mean, spare the rod, spoil the child. So you have to find out, why are you going after your brother? Some people I'm not, one of my guys that, there's a friend of mine, he got terminated from a company back last December. He goes, "I want to go after him, Gordon, do this." I said, "Why?" I said, somewhere in here you got to be. He said, "I was there 3 years," and he doesn't want to. He's not talking about because he expected to be there for life or anything else. But his attitude is such that I don't sense it being the right kind of attitude for it. So I'm not like wanting to like really jump in with both feet and help him. I'm giving him some guidance on it because I want him to learn, because I'm hoping to bring him around to, being a little responsible for himself. Comment was, this state doesn't have very good benefits. The unemployment's running out and this and that. I said, so you think the state should provide better benefits? Yeah, like some other states do and stuff. We got a long ways to go to get him out of debtor status up to creditor status, because he's looking for benefits, someone to take care of him. So I said, man, you should be hustling a job, dude. You should be getting busy. There are jobs out there.
Can you make a comment about allodial title? Because you were saying yesterday you were focusing on that area.
Fee simple as opposed to allodial title, or allodial title distinguished from fee simple. All right? Let me give you allodial real quick.
Allodium. It's the same word.
Yeah, just a variation. In allodial, allodium.
It's the responsibility that goes along with the allodial title too.
Yes.
Well, I like allodial personally. I'd rather be not getting certain things.
I've heard somebody say in BC you can't have a road because all the land's in dispute. Is that true?
Who says they own it? I don't buy that.
The
Allodial.
natives say they own it.
Allodial. Of an allodium, freehold. Go to allodium. Law. Land owned independently, free of any superior claim and without any rent, payment in service, etc. And when you go to fee simple, fee is another word, feud. And it's ugly when you go to fee simple. And it's subject to all sorts of stuff. In fee or in feud. Let me go to it.
Gordon, may I read this out of the Canadian Law Dictionary?
Sure.
Owned freely without obligation to one with superior right, not subject to the restriction on alienation that existed with feudal tenures, free of any superior rights vested in another, such as a lord. No person can now have such an absolute property, since the highest estate is in fee simple.
I want to buy that lie. It's in state in fee.
Law Dictionary.
Well, that's Canadian law. Like California law. Well, Canadian law don't supersede contract law, does it?
No.
Sears law and McDonald's law doesn't supersede contract law. And if we went to your Constitution, you'd probably find that no state shall impair the obligation of contract in your Constitution also. Because and this goes back to the King John, with Great Writ, Magna Carta. They're just things you can't do to free people. You can't enslave them. You can fool them to enslave themselves. That you can do. But it's not like there's some entity trying to do it. It's just what things do. It's what people do to people. So, he who fails to assert his rights has none. So fee simple and the rest of that. Let's run back to this more. Contracts move because they are dynamic. Well, essentially, yes. Is this because we can verbalize them again at any time? Well, you can not only verbalize them. Let's say, one of my problems, some guy says, can you get me out of prison? I said, well, it's a little bit of a problem because trying to teach you who you are. So when they hand out certain things like you got this much time or some kind of a deal, if you just accept and don't give it back, what you've done is without verbalizing anything, by your actions, you've agreed to accept the sentence. Or if I go into supervised release and she gives me a copy of the judgment and commitment and I take it with me and don't return it, it is. Or if you get a bill from Visa, a statement, and you keep the statement, or the IRS, you didn't have to verbalize anything. Let's say that I'm out of the tax system, the IRS system, but say some year they send something to Gordon Hall and says, we haven't received your tax return for 2009. That's an offer for me to be a taxpayer. You know, a couple of those letters, and I might just find myself or Gordon Hall being charged with willful failure to file. So anything that you get, so it wouldn't be just a verbal one, it would be a written too. Remember that contracts are express or implied. The express or manifest, viva voce, which is by the voice or speaking, or by writing, implied or shown by silence. So there's instances where they assume and presume you to be, are all those inmates in prison that aren't asserting their rights, are they entering into a contract daily by wearing the name tag? You know, all capital letters with the number on it? I refused to wear one. That got me thrown in the hole with my buddy. Never did wear one for the last 18 months I was there. Just me and him were the only two that wouldn't wear them on the compound. That
So
didn't.
the contract can change just because our understanding of it changes. Like a mortgage.
Let's
When
say-
I first had my mortgage, I believed they loaned me money.
Right.
After that, now I know that they created it on my signature. So
Okay.
that's it. The contract's changed, because in my mind.
Well, as contracts
I understand-
change in your mind, that you've been frauded, so does fraud vitiate all contracts?
Yes.
So whatever agreement that's been more memorialized via monthly payments on that can be undone based on fraud. Right? Wouldn't matter if it's fraud or not, you can make the thing move. Just fraud's a nice thing that causes them problem and incurs damages and all sorts of things for them. To allege fraud, put the stuff in, prove it, and take it all the way. So you can learn how to assert a claim, whether it be someone that borrowed a lawnmower and won't return it, to an IRS, to a warden who lets some guard take your chess set, who he's responsible for watching, to you name it, to Farmers Insurance that doesn't want to cover a guy's claim because it's not covered.